Testing. Testing. We'll get started. How's the audio? Let me see. Okay, can y'all hear me? Can someone unmute and let me know?
We can hear you pretty well, loud and clear.
Perfect, perfect. Okay. We'll get started. One second.
Brian.
Yes,
Oh.
I'm here.
Yes.
All right. Just get everything set up. Okay, cool. So tonight's gonna be a fun topic because I sort of talked it up. And Vance may jump on here because we were actually having a conversation a few weeks ago. And we were talking about a scenario where you dispute a collection and then turn around and decide that you no longer want it disputed. And the question was, would I be interested in that kind of case? I told him I didn't, it sounded like a reverse E8, because the E8 case is where you dispute something and then the debt collector under 15 USC 1692 E8 has to market disputed. And what I coined to be a reverse E8 is where you undispute and likewise assume that the debt collector has the obligation to market as undisputed, basically remove the dispute notation. I was not interested in a case like that because I had not yet seen a court analyze that type of scenario. So, and then he sent me this case, which is a recent case. But anyway, let me show you E8 just to refresh your memory. 1592 E8. E is about false or misleading representations. And then E says the debt collector may not use false, deceptive, or misleading representation or means in connection with the collection of any debt without limiting the general application of the foregoing. The following conduct is a violation. We're going to skip down to 8. 8 says communicating threatens to communicate to any person information that is known or which should be known to be false, including the failure to communicate that a debt is disputed. So that's what E8 focuses on. And like I said, the whole idea of taking back a dispute the question was, is the debt collector obligated to now unmark it as disputed? Okay. And we now have an answer to that. And let's see. And we have this court case. It was an 11th Circuit. The 11th Circuit, which is the Southeast United States, Georgia, Florida, Alabama, has some great decisions overall. And this is just another one that came out that really, well, it didn't just come out, but that was in 2022. But I think it's a great decision to illustrate how a scenario like that can work. Let me let's start off with the complaint. We're going to go through this, and I think y'all learn a lot. And I posted days ago so that y'all can sort of have an opportunity to read it, so that this may not be your first time looking at it. Let's see. Okay, so here's the complaint. David Sanchez against LVNV funding. I just filed a case against Resurgent, and I think we have a case we're about to file against LVNV. But let's take a look at this case. This is a FDCPA case. And let's take a look at it, and then take a look at the summary judgment motion and the decision. So this is in the Northern District of Georgia, which is, like I said, as far as appellate circuits, it's the 11th Circuit, but this is, a district level case, meaning it's in just a district federal court. It's not an appeal or anything like that. But it still, is authority for, this circuit, this decision. So Sanchez versus LVNV funding. We all know LVNV is a popular debt buyer. We also know that they buy debt, and a lot of times, well, buying debt, they're a debt collector, and because they buy it already defaulted. And then you see a lot of LVNV collections being serviced by Resurgent, who is a debt collector. But LVNV would be the debt buyer, debt collector. All right, so this complaint says Daniel Brennan alleges that, it's an FDCPA case. This happened in Georgia. This person is a natural person, okay? It's a natural person residing in Cobb County, Georgia. LVNV is a foreign LLC in Georgia. LVNV is attempting to collect a consumer debt allegedly owed by plaintiff to Credit One. Okay, we know LVNV buys those defaulted debts, so it's $738. Defendant is reporting the item with a dispute comment on plaintiff's credit disclosures. All right, that's very strange. Yeah, so when you see this disclosure, you all know what they're looking at, right? This should trigger you to know that they're looking at what I don't want y'all to look at, which is a disclosure from the CRA. It's not coming from a reporting agency. I'm sorry, it's not coming from a third party company, but it's coming from the reporting agency itself. Don't recommend you do that, because now, it becomes an internal situation, a third party. It's not on the credit report, consumer report, I should say. So anyway, it's interesting that they are operating and litigating off of disclosure. All right. Plaintiff no longer disputes the collection item. All right. This might be the entry. Well, it says general allegations. You know, when you read these things, this case is going to be a good case to illustrate how the courts think about this. But as you look at this, you know, I'm gonna think aloud because there's a way this could be better. It would be better if this person actually obtained a consumer report. Number 8 would be better if it says, if it gave more. Now it might give more detail down here, but it would be nice to give details chronologically, because you see here in number 7, they say that the defendant is reporting the item with a dispute. But wouldn't it be nice to know why? Wouldn't it be nice to know, to say before that the plaintiff, you know, disputed it? So you see how this is sort of arranged in a scattered way, because we were talking about the defendant marketed disputed here, number 7, but we don't know why. So we have to read and come back and say, oh, that's why. So be careful about telling the story in this particular order. Sometimes, the reason I went back up is sometimes you'll have what's called an introduction. And in an introduction, you can give your main points. But when you're in the general allegations part, it seems like you'll want to tell that story in an order that reflects what happened and when, in natural order. This doesn't seem to do that. Plaintiff no longer disputes the collection item. Okay, so reading this is filed November 22nd, 2021. So when did plaintiff no longer dispute it? Okay, so it's really tough to understand. Is it as you're writing this complaint that you no longer dispute it? Because if that's the case, then that's the first time this debt collector is going to know about it. So you see how this could be improved. Now we got some dates coming up, so maybe now they're going to get specific. But again, it'd be nice to be chronologically told what happened. On August 12th, 2021, let's see, this is November, so it's not fun. Plaintiff obtained his Equifax credit disclosure and noticed defendant reporting the collection item. Is anyone else having a hard time reading this? The collection, okay, because you didn't define the collection item. Okay, here it is. Should be a capital. Usually when you define terms like this, you would capitalize the abbreviated thing. So the collection item is right there. So it'd be nice if they would capitalize that. So on August 12th, plaintiff got the Equifax disclosure and noticed that collection item and this can't be correct either, because this collection would be listed by defendant, but when you read this, it says what the underlying item is, but what the person likely saw was an LVNV trade line for 738 with an original creditor of credit 1. So I don't know. This guy, I don't think it's written all that great. Yes,
Brian,
Gene, go ahead. I
excuse
see
me.
your hand. I see you.
Yeah. No, just like on the exhibits that you provided, they're using the terminology loosely, they're saying disclosure, but in reality, it was a Credit Karma Equifax credit report. They're just
It
calling it a
was Credit
disclosure.
Karma?
Yeah.
Okay, okay,
Yeah, yeah, it
so,
was Credit
yeah,
Karma. Yeah, yeah.
yeah, yeah, so, yeah, I mean, let me see, who wrote this? Let me just think. Daniel, okay. Yeah, these guys, they're very experienced attorneys, so it's really weird to see them do it like this. I don't know Daniel specifically, but I'm familiar with his.
Could they have had their associates write it?
Possibly, but that's never an excuse. Like if you all that are wanting to help me, if y'all write it, that's I still have to approve and review it. But you're correct. I mean, someone, this is a big firm. They do a lot of cases. So you're right. Someone could have written it, but again, it should be approved by Daniel. But yeah, I'm just noticing as I go through this, it could be better. On September 1st, 21, Credit Repair Lawyers of America, on behalf of plaintiff, sent defendant a letter informing defendant that the collection item is inaccurate and asked defendant to remove the dispute comment from the collection. Okay, so again, I'm reading this now. You're wondering, where is this dispute comment coming from? You don't know yet if it's even, perhaps it is right now. It seems to be just coming out of nowhere. All right. Defendant, okay, that the collection item is inaccurate. Okay. So if it's inaccurate, so if you're writing a letter saying that the collection item is inaccurate and to remove the dispute comment, how can you do that? Because if you're saying it's inaccurate, what are you doing? Disputing it, right? Y'all follow me? So
Yes.
this really
Yeah.
makes
So
no
so
sense.
so 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 yeah, man.
Yeah.
I mean, I had a mental sparring match with a guy about it, man. And I mean, I just broke down and left it at that. But I like the ruling of this case.
Yeah.
But
Yeah.
that complaint
It's
is one
horrible.
thing.
Yeah.
That dispute is another.
Yeah. So we're gonna get through it. Like I said, obviously we like the court analyzing it finally, but yeah, this thing is just written weird. You just disputed it. Now,
Because that's the glory of it. The dispute is for you to remove the dispute.
now,
So yeah.
okay. Well, I got to read the dispute then. The collection item is inaccurate. If you're saying the inaccuracy is the dispute, then yeah, okay. So I need to just we'll continue because we don't know how it's inaccurate. I was assuming it was inaccurate by way of, the person doesn't owe what you're saying is owed. But I guess we have to wait to read this exhibit. And then let's see, where's the exhibit? All right. And then look at this. It's not even really giving us details. All right. So those exhibits will come until later. All right. Defendant received the letter September 7th. All right. It was sent on the 1st, received on the 7th. All right. On October 25th, 21, plaintiff obtained his Equifax credit disclosure, which showed that defendant last reported the collection item reflected on October 5th, which is after September 5th, and failed or refused to remove the dispute comment from the collection item in violation of FDCPA. Okay. So again, until we see that dispute letter, we don't know how it was stating that something was inaccurate, because if you just say it's inaccurate, the collection item, remember, collection item is what? All the stuff we read here. A consumer debt allegedly owed to plaintiff. It didn't say the collection item included the dispute notation. And so down here it says the collection item is inaccurate. The collection item is defined right here. It has nothing in it that says dispute. So you see where I'm coming from? So anyway, we'll see what that letter says. Defendant received a letter on the 7th. Okay, the 25th, it got a disclosure. On the 5th, it was updated and it didn't have that dispute comment removed. With disputed item appearing on his credit report, now we call it credit report, which really should be consumer report, you know, plaintiff's FICO score is reporting inaccurately such that he is not eligible for, okay. This doesn't make any freaking sense. So a FICO score isn't accurate. It's always accurate because it's reflecting what's on the report, but it can be higher or lower. So it would be better to say that the FICO score is lower than it would be due to the disputed item appearing in the credit report. Now, but not only that, go ahead.
Hey, Mr. English teacher. You
Yeah.
know, when we write these
Spanish,
these
teach
complaints,
Spanish.
you know, we just trying to put that, you know, that Article 3 in there. You know, it's allegations. You know what I mean?
Yeah.
It don't gotta be true. It's just
Can you pull up a picture of who writes your complaints and show everybody?
yeah, my baby boy.
No. Just show them right. Pull up a picture if you can, and show them who
Yeah,
writes.
my baby boy.
I'll see if I can.
3-year-old. Yeah, my 3-year-old.
Send me a picture on the WhatsApp, and I'll put it. But yeah, Vance's son. Yeah, Vance's son writes his complaints. How old is it? Yeah, I think it's 3. Okay, so
Yeah, 3.
All right. Mortgage rates are now historic lows, blah, blah, blah. Okay. And we're not going to take too long on this complaint. The credit report industry, such as defendant, communicate, furnishers like defendant communicate electronically with the credit bureaus. Oh my God, Jesus Christ. All right. Defendant has had more than ample time to instruct Equifax to remove the dispute comment from the collection item. All right, here we go. And channel, let's see. Here we go. Oh, he's a fireman too. Okay. This is Chandler Dobson. And he writes Vance's complaints. Okay. That's Chandler. I got it. He does a pretty good job. You know, I just have to correct some stuff.
I don't think they see the thing, the picture.
Oh, well, no, I put it in the
Oh,
I'll open it, but I'll put it in the WhatsApp chat. But let me see. I'll put it in the WhatsApp chat.
Good boy.
Don't tell his mama DNA test pin.
Probably not going to do that. So yeah. So Chandler, he writes the complaints, and then I have to edit. You can tell he writes them. But defender has had more ample time to tell Equifax to remove the dispute comment from the collection item. Defendant's inaction to remove the dispute comment from the collection item was either negligent or willful. That doesn't matter. Somebody. I think this attorney's child may have written their complaint too, because
Yeah, because I had a question about that.
Yeah.
Why would they write negligent or willful? Like,
I'm cracking up.
They could be 3 years. It could be their son. If you want to Google that guy and see if he has any kids, his kids might have written that.
Child's play.
The reason it doesn't matter is because only with the FCRA does negligence and willfulness come into play. FDCPA is a strict liability, so it doesn't matter whether it's negligent or willful. If it happened, it happened. The defense could be that it's unintentional and they're stuff into, it's, you know, I can see if you want to say that it was, if you want to say it was anything, you would say it's intentional. Okay, because the defense is it being an unintentional bona fide error with procedures in place to prevent that. So if you're going to say it's either negligent or willful, then if I were defending this, I would say, yeah, it was negligent. And so it will support an unintentional defense, right? So anyway, this is really tough to get through this complaint because of these little errors or issues. But again, these people must go to church or something. Stuff turns out okay for them. Plaintiff suffered pecuniary and emotional damages as a result of defendant's actions. His credit report continues to be damaged due to defendant's failure to properly report the collection item. Okay. All right. Well, that should have been 2 sentences, but plaintiff reincorporates the preceding allegations by reference, violation of the FDCPA. Defendant in ordinary course of business, okay, they're a debt collector. Plaintiff is a consumer. Okay. Okay. Defendant is a debt collector. Defendant's foregoing acts and attempts to collect the debt violated 1692E. Okay, we got an E2 case, falsely represented the character. E8, reporting credit information was known to be false, including the failure to communicate the debt is not disputed. See, they made this up. That's not part of E8. But remember that list I gave you and that they're doing is not exhaustive. So it could go both ways. Right? If they're failure to communicate that it's disputed, but what if it's not disputed? It can go both ways. Remember when I told you that list is not the only list? And so this case shows you that saying that something is not disputed and they're calling it disputed could be a problem. But again, I do want to see the dispute letter, which is attached here, because you can't say that it's inaccurate outside the dispute, because the way he wrote it in the complaint, it said the collection item is disputed. And in the collection item, that sentence didn't have anything about the dispute notation. So I would call this a poorly drafted complaint, poorly, but it worked. Plaintiff has suffered harm and damages at the hands of the defendant as the harm was specifically identified and intended to be. All right. So that's a good allegation. Okay. That's a good allegation. I would say this is probably one of the best allegations. Number 22 is a good allegation. Okay, so this is a very important allegation because it's going to get Article 3 standing. That's why the case is still in there. Defendant's failure to remove the erroneous dispute notation from this collection item is annoying, humiliating, and embarrassing to the plaintiff. This creates a false impression regarding his credit worthiness. Okay. I mean, that's good. No. To date, as a direct approximate cause of the defendant's failure to honor its obligations of FDCPA, the plaintiffs continue to suffer anxiety. These are all good allegations. 23, 22. What? Oh, you see that the numbering's messed up? Oh, Jesus. Oh my gosh. 22, 23. Oh man. So yeah, I think Advance, do you think did Chandler write these or no? I don't know. Chandler doesn't work for them, does it?
Yeah, schoolmate do.
Okay. It could be well. This is in Michigan, so I don't know. But he may have his kids write it. So like I say Advance. You pay Chandler or you just volunteer work? This is true.
Yeah, I pay him in
Those little cups with the animal on top of.
yeah, what the hell is that called? Kinder eggs.
Those are drinks.
Yeah.
With the stuff on top of it.
Mm-hmm.
Yeah, you like that. All right, plaintiff praise for judgment, actual damages, costs and transfers. All right, demand back. jury trial. Okay, so yeah. So anyway, that's the complaint. I just wanted to show you that. So there's no attachment to it. I don't think. Let me see. No, that's document 1. Yeah, so it's no attachment. So 26. This is the motion. So obviously this case now, this is like a year later, well, almost a year later. The case is going through discovery, all that good stuff, but there's summary judgment phase. So the plaintiff filed for summary judgment. And here are the facts that it's based on. Plaintiff sued LVNV. The complaint alleges a violation. Talk about E8. Defendant admits receiving a letter informing that the collection is reporting on the Equifax disclosure is inaccurate, and asked defendant to remove the dispute comment. Defendant admits that it did not remove the dispute comment, okay, from its trade line as requested. Defendant continued to communicate the inaccurate trade line with a dispute. After that, okay, there's no genuine issue. You know, it happened. It is what it is. It's a simple and straightforward motion. The lawsuit arises from defendant's failure to remove a dispute comment from Equifax, from plaintiff's Equifax credit disclosure. After being asked to do so, defendant through his agent admitted that it received the letter requesting removal, and it didn't do it. Defendants attempted to collect that credit card collection. Exhibit 1. The debt was incurred, it's a consumer debt. All right, that September 1 letter. So let's look at this September 1 letter. Well, I'll go to exhibit 2 first. This is how it shows up on the disclosure. Oops. Do not use these, y'all. My goodness. But anyway. You see it here? Consumer dispute. So they put this dispute on here. Now I don't see how this is going to hurt more than the collection itself, or separately, but whatever. Number 3 is the letter. So let's look at this letter and see how this plays out. Okay. It's the LV.
Brian,
Mhm.
can you go over again why, besides the fact of what we're seeing here, which was intentional with removing the dispute, in general, are we just moving the dispute to catch them, or there's a benefit to that generally for your credit?
I don't think there's a benefit. Oh, well, I'm sorry. Let me say this.
Hey, Brian.
Hold on for a sec. Hey, but hold on one sec. This guy was applying for a loan, allegedly, and underwriters do take issue with disputes on the report. Now, they also take issue with the collection. They want you to pay that. But I will say that, knowing the lending area a little bit, is that underwriters do not like disputes appearing, okay, on a report. So it is a possibility they could have applied for that loan or something and may have had an issue. I didn't really read that, but I did read it in the complaint about that loan. So that's a possibility. Jerron?
Oh no, I was just finna answer her. That's why I was gonna tell you that's what he was trying to do.
Okay.
With that.
Oh, okay. Well, let me see something. All right. Okay. Okay. Perfect. So yeah. So there is, and maybe in the brief they may talk about that, but yeah, there is some issues with disputed stuff when it comes to getting a mortgage, residential mortgage loan. They don't want to see that. Now, I don't think they want to see the collection either, but that's another story. But I guess they both have an impact. My firm represents David Sanchez. David Sanchez identification information is, that's his address. He has received the credit disclosure What? From where? Okay, anyway, I guess they know where they reported to. Credit has reviewed the credit disclosure and has discovered the following inaccurate information on the file. Okay, okay, no longer. You see what I'm saying? What's going on here? No longer. So did he ever? This is just it's so many questions. Oh,
Yeah, it really is.
no longer. All right. Anyway, please remove the dispute. Okay. So that, I mean, that makes you think that at some point he did. So, all right. Well, nevertheless, like I said, even if he did at this point, he no longer disputes it, right? So if you no longer dispute it, then it has to so reflect that. So that's, you know, that's ultimately what it is. You
So
can't
I'm
beat. You can't,
confused. So he never if he never disputed it.
we're not saying that.
Oh,
We
okay.
don't know that.
Then
That's the
when,
confusing part. We're both confused. So
okay.
we're not gonna know that unless we talk to Gary or David. But that is the confusing part. So we're gonna remain confused because we don't know unless is David Sanchez on?
I think that's normal. That situation. That's what I had. I no
Yeah.
longer disputed it.
Well,
But the question is, did you dispute it?
Yeah, I
The first
disputed
amount.
it first.
Yeah.
I disputed it, then I asked her to remove it.
Yeah.
That's
So, and then I guess her question was, Nancy's question was that because of a certain reason? So did you do that because it was causing an issue to you, or you want to catch them like Chandler if you do it?
Yeah, my situation was different. I like they actually made a change.
No, the motivation on why you wanted to. The question is, what was your motivation?
So I told him I was worried about.
Jesus.
I told him I was worried about it affecting me, like whether or not it's going to affect me or not with the mortgage. I just told him I was worried about it. So I had emotional distress. So
you stressed about it. Okay, okay. So your motivation was you were worried that it may cause an issue, but but you had disputed it before though.
yes,
right? Okay, all right. You didn't send him a GB letter though, right? No.
it was more of an SCRA dispute. I sued the borough.
Oh, okay. The Farmers Bureau or the
Yeah, I was saying,
Federal Bureau of Investigation?
It was Equifax.
Equifax Bureau. Okay.
ED. Bureau, man. What a bureau.
All right. All right. Cool. Are y'all familiar with the Farmers Bureau?
Yeah.
That's insurance company. Okay.
but
Yeah.
Brian, just
Go ahead.
back to what we were saying. Let's say he didn't dispute it and they just
Yeah.
happened to write that. That would be inaccurate too, and that would be a reason to get it off as well, right?
Yes. Yep.
Okay.
Yep. So you say a reason to get it off. So listen, so let's think about this. Let's assume David Sanchez never disputed it, but it was marked disputed. Then that's an E8 violation right away.
Mm-hmm.
So you don't have to.
So what's the dispute, Brian? Let's talk about the dispute, man. What's the dispute?
I'll let you go ahead. I got you tell him because you got your you know.
What a dispute is calling it into question.
That's it.
Mm.
That's
Casting
it.
doubt.
Casting doubt. The advance. He studies that. He studied that deeply because he knows different ways to dispute. Okay, we got a couple of messages. Thomas was saying he settled one against CRA and cited Rodriguez versus Equifax. Okay, cool. I'll post that comment in the WhatsApp so we can look at that. So I want to look at that. But very good, very good.
Hey, Brian.
Go ahead.
Why I didn't see Thomas's comment, man?
Oh, okay. Yeah, it's in the chat. You see it?
He's secretive, man. That's secretive, man.
You don't see it? It's in
No.
the, you gotta click the chat in the you gotta click the I'll send it to you, but you gotta click the chat window in the Zoom.
I don't see it.
Credit Karma. Okay. Only was
Oh.
saying Credit Karma.
Yeah.
Was applying for mortgage, that's right. Sued who? Okay. I don't see it here. You don't see it? Huh. Well, I sent it to you, man. So I'm surprised you don't see it.
Yes.
Okay. Like you said, Thomas. Okay. So, all right, no longer disputes it. But like I think I already told you, so we don't really know whether it was disputed or not in the beginning, but whatever the case, it doesn't really matter because if you're saying you no longer dispute it, which is what the letter says, then you have to remove that under E8. Okay. They got the letter. They use online certified mail. This is good. You know, you see, I always encourage this. Okay. Now I don't think Chandler uses the certified mail to use.
Yeah.
But y'all don't do the. But that's for what? What is that in that though? It's not a dispute, right?
Yeah, no.
All right, that's for a complaint.
Yeah,
For the complaint, but
No.
just yeah. But you see, they got it. W. Brandon. Okay. All right. All right. So that's a dispute. All right. So that was what it was. Let's see what the debt exhibit is. Exhibit 4. Okay, it's showing that it's still showing up, perhaps. Yep, still showing up there, saying disputed. Oops, sorry. All right, this is October 5th. This is after they got the letter. Okay. And then what's this? Number 5. Interrogatories. Okay, this is probably them admitting or acknowledging everything. Okay. All right. Well, all right, let's read it. They admit receiving a letter. So, okay, that's the case. Okay. And basically the argument is y'all need to do it. Okay. Y'all read that. Let's go what the court said. We don't want to take all the time on that. This is what we really want to hear. Plaintiff had a credit card account. Credit One Bank became delinquent. Defendant, which owns a portfolio of unpaid accounts, acquired the debt. These opinions are great. When you read these, sometimes you can you see this language and see and you can piggyback off the way they describe it. The court's going to write it in a way that it can understand it, so you can sort of learn you can learn how to fashion your language in ways courts can understand. And what I do is this: when I have a case in my circuit, I'll look for cases like mine and find opinions like this that support my case and make arguments in my briefs, just like the court did, Now, also, you see this kind of language, you can also use it for your complaints. And describing, what's going on in the case, because the courts can recognize it and understand it. The services accounts, you see they engage Resurgent. Remember I tell you about that? Resurgent identifies itself as a debt collector. Now that's interesting, but well, I guess it's cool to identify, but it's also good to, well, anyway, I ain't gonna get into that, but I guess if they identify as one, then they are one, but they are one. Because
hey, you remember about 10 years ago?
What you identify as, man? Pronoun.
A serial sewer.
Okay, go ahead.
So you remember about 10 years ago, we was tiptoeing on the water.
Marble floors?
Yeah,
Okay.
and we was looking at trying to get that credit repair fee paid through actual damages, saying that there was an actual damage.
Yeah.
Hey, I'm finna ramp that back up, man.
You got to. That's a cost. That's a damage.
That's a damage, man.
Had to, yeah. Even a stamp. That's what I tell people. Just
Oh yeah, I remember
send
that.
that stamp. People just forget, man. A penny. Y'all so rich. Y'all act like a stamp. It's not a damage. That's damage.
The stamped envelopes, the same, right?
Yeah.
Cost
Even the
money.
envelope itself, you have to pay for that. Ink on the printer, time, whatever. Okay. October, plaintiff through a credit repair company sent defendant. See, that's interesting. You see, that's why I don't like that letter, because they call them the law firm a credit repair company.
Law firm is a credit repair company.
It could be, but that's what they are. Resurgent responded to plaintiff.
What are you? What are you, Brian?
Law firm.
Okay.
Law firm.
Okay.
Okay. I just happen to help people with credit. Because I don't want to be stuck under the
Bro.
accrual and all that stuff, because I practice doing the same thing. Resurgent responded to plaintiff with an account summary and letters notifying plaintiff that it was a communication from the debt collector and took collected debt. Okay. Okay. Well, that's just a response letter.
So what would you value this case at? What would you value this case at?
Well, you can't really value it. It could be a six-figure case. They spent a year on this, man. It could be a six-figure case in fees, and then damages on top of that. This definitely could be a six-figure case, no doubt. He listed LVNV, his unpaid credit card, and a notation that this account is not. Okay, so let's look at this. Okay, so he disputed this. Look, you see this? He disputed it first. And see, I guess we don't know this until we get into the case. Because all of this stuff, and this is what I've learned in litigation, it's sort of unfortunate, but you gotta put all this stuff in the complaint. You can't, this stuff right here came up later in the case. This stuff I think should have been in the complaint. This is walking you through what happened. You see,
Man, that's kind of it's kind of BS, man. First you talking about it's not mine.
Yeah, then all of a sudden you don't dispute anymore. Okay, but
come on,
notation
man.
that it's not mine, and that messes up his credibility. But anyway, testified he knew the credit card was his, but was unsure how the defendant was connected to it. So that's how he tried to fix that. Okay. Yeah. So, that's why he didn't put in the complaint, because ultimately that came out probably in a discovery, and they didn't want to type that out. It's not mine. And see how I tried to clean up. He wasn't sure how the defendant was connected to it, and I can understand that. You see a collection, and you have internet gurus, like Dance. And I'm not saying but Dance, but debt collector. That's not your debt. That's. But I understand, and I agree.
Hey,
What?
I seen a reel.
Oh, okay.
And it had 100-something 50,000 views.
Mm-hmm.
Talk about a TransUnion hat. I'm like, oh my God.
TransUnion. Okay.
Oh.
Plaintiff testified he knew the credit card was his, but was unsure how the defendant was connected to it. That's fair. Okay. Well, yeah, that's fair.
Was this a recording?
What you mean?
Meaning, like, how did it come out that way that he said that the account is not?
I don't. There's probably
Couldn't
discovery.
they reword it a different way? Okay.
Well, this is likely. It's in a letter. See, it says letters, and so the quote is probably from language in those letters.
Oh, okay. Now that makes sense. Yeah.
Plaintiff testified he knew. Okay. Defendant later sued plaintiff on the debt and obtained a default. Default judgment. He said, "Oh, okay. Yeah, default." Plaintiff sued. Oh, defendant. Oh, so LVNV sued plaintiff got default judgment. Oh, okay.
Hmm.
Oh, okay. And so
Man,
that's slick.
see,
So he
that's
got
why I
money off of
love.
that. That's
See,
why he
see, that's,
undisputed it. Okay.
yeah. See, I love. That's why I love that EA shit, man. Because
You
say
can
for
sue.
example, if the information ain't disputed, and then they just enter anything in the answer denying it, then they automatically got to mark it disputed. So if they don't mark it disputed, you just counterclaim it or amend it and do all of what you got to do.
Well,
That's yeah, man. Hey, I'm telling you, I'm telling you.
well, if the case is already going and you're just now disputing it, I don't know if that, let me see, that dispute, that counterclaim has to be something that existed at the time I think the original case was filed. But I understand what you're saying, but it could be a separate case. But I understand what you're saying. But the point you're making is, I guess we're all seeing is, and they can have a default judgment and you still can get money. I mean, like I say, this could be a 6-figure case. So this LVNV sued this plaintiff. And obviously that's a good reason to mark it undisputed now because it's you got a judgment. It's definitely undisputed. So this is actually very smart. So plaintiff never paid that judgment. He definitely gonna have to pay it now. And so then they undisputed. They engaged a credit repair firm as counsel. Yeah, I wouldn't want to be called a credit repair firm because of the core obligations, but they're okay with that. Yeah, okay. The firm quickly sent defendant a letter explaining no longer disputed the account, asking defendant to remove the dispute notation. In October, they obtained a copy of his credit report. It showed with the dispute notation, plaintiff sued. Okay. So we all know these facts, right? Let's go to summary judgment. Summary judgment. The non-moving party has the burden of showing summary judgment is improper. The moving party has the burden of showing there's no genuine issue. Okay. I mean, look, this is not disputed. The facts, that is. Obviously, the legal conclusion is disputed. So understand when they say no.
I never knew what. I just put it in there, man.
Yeah, that's what it means. So there's no genuine dispute as to the facts. Because when you say, oh, there's a dispute, I didn't violate the law. That's not what they talk about. No genuine dispute as to any material fact of what happened. Not a dispute about whether you agree it's a violation or not. So that's what that means. All right. And then the moving party has to show that there is the non-moving party has the burden of showing that it's improper and that there are specific facts creating a genuine dispute. Okay. So, oh yeah. So R&R means recommendation by the report recommendation by the magistrate judge. And that usually precedes the basically if you don't object to that, then the magistrate's opinion will become the district judge's type. It'll adopt it if you don't object to it. That's what you're talking about here. So I'm just going to move past that. You can read that on your own. But discussion.
Now here come the juicy part, man. That's the
what they say about
juicy,
standing.
that's the juicy.
The standing says he alleged injury is from his alleged inability. That's not true. Oh, that's what defendant claims. Okay, that's right. Because they lying like they just lie. Only alleged injury. Y'all, I just read this, and that's not it. He talked about their score. But anyway, plaintiff never actually applied for more. Okay, well, that's talking about. But like Thomas was saying, it's a fear. But anyway, defendant says plaintiff suffered no actual injury. Well, I don't really care about what defendant says. They feel crap. Let's scroll down. Now, and this is in the circuit. Emotional distress is a tangible injury. Okay, so the judge is like, look, that's not only what they allege. And the law says tangible injuries are qualify as concrete. So they allege emotional distress. We read that. Plaintiff testified his perception was the main drive of the distress. So that's fine. Now, in some circuits, I think like
10th Circuit, it just going to
yeah,
but
at
11th Circuit,
in-
they
in
getting it
this-
right, man.
in the 7th, I think they may not recognize emotional distress. In the New York Second Circuit, they do. But
They
it's
don't
not,
in the 7th. The 7th is terrible. They
yeah, that's what I said.
they don't recognize it.
Yep. And then in the second, they do, but it's a lot of twists. It is a lot of twists. You could allege, like I have a case that I got remanded. And of course, being remanded means I filed it in state court and they removed it. I allege emotional distress, but it got remanded because I have to pull it up for you, but you have to put it on a certain kind of platter for you to be able to serve it right. You know what I'm saying? So you can allege emotional distress, and if it's not worded properly and talked about, you know, you got to court the court, then it's not pled well enough with facts. So I think I said my client suffered emotional distress because of the conduct, and I was still able to get it remanded because it wasn't pled out fancily they want facts on top of facts to explain those damages and how it's connected. You remember when I showed you in the complaint how they really worded it real nice and congressional intent and all of that, just the kind of injury. They put some ribbons and Christmas wrap on it, okay? It's just like Easter's coming up, right? And the Easter baskets, they don't just have the eggs in it, right? You wouldn't buy that for your kids, would you? If it just had some white eggs in a brown basket. Would y'all buy that? But it's the Easter egg in there. It's a boiled egg. And so that's similar. That's the emotional distress. But so if you got to put that green grass on it, you got to paint the eggs, and you got to have the colored basket. Then it's a proper emotional distress. So that's the best way I can explain to you in New York. You can have the Easter egg in there, emotional distress, but if you had that grass, the paint on it, now I think Vans, they shrink wrap. I think y'all shrink wrap the little plastic design on it. Y'all don't paint it yet. But over here in Georgia, Mississippi, and all that, we just dip it in you dip it in what? You dip it in some ink. Well, nah. It's the whole egg. You dip it in some ink. But I know y'all got the fancy plastic and stuff. You just shrink. So anyway, plaintiff, yeah, he put it down. Plaintiff, here we go. Hold on a second. Plaintiff never applied for the mortgage or presented any evidence that that was just what he thought. Plaintiff, therefore, has failed to present any evidence the conduct has actually caused. So there you go. Now, I have a case. Is warning here. You might be frying some chicken. You find some chicken, but Warren, we have a case, and to avoid this, you see, there's no, we had to get some evidence.
Like Van said, go buy some Tylenol. Keep the receipt.
Well, yeah, more so see somebody. Go see some therapy.
Man, people think I'll be playing, man. I'll be trying to tell people some free information, get some money, man. I'll be like, dude, hell with shit.
Yeah. And so you see how the court's talking about it was just what he thought. I mean, that's the stress. How you gotta I mean, whether you apply for a mortgage, it's like saying you thought somebody was gonna hit you, they didn't hit you, but okay, well, but you were scared. You had the distress. So anyway, this stuff like this, what you got to do is learn from it and understand. Just because like for example, Thomas mentioned he feared, well, he would have to apply for something. You know,
I mean, I get it,
get
man.
disputed.
It's easily, anybody can easily say it. Like you get into
what
a
you
car,
thought, right?
you get into a car wreck. Oh, my back hurt.
So they want you to see somebody, right? Because you still saying the same thing, but they want you to see a doctor. If it hurts so bad, you see a doctor. Well, if you were so scared, were you scared because you just scared, or because you could be scared for no reason? You should have applied and had something real scared, something to really make you scared. All right.
I got one question.
Brian,
Somebody, whoever was first, it was a gentleman first, and then somebody.
So they're requiring I know like in the Fourth Circuit, a lot of other circuits, I'm not sure. They just want somebody corroborated.
Yeah.
They don't necessarily
They don't
want
trust. Yeah, they don't trust.
Yeah, 10
Trust.
gotta have a witness. And that witness can be your spouse.
Yeah, corroboration is exactly what I would say. So no one really cared because anybody can think, they feel anything, corroborate it. If you stress, log on to that. What's that website? Anyway,
But a good thing about the 11th Circuit, they do that self-serving affidavit, man.
Yeah, that might be something you could submit something. But go ahead. Who's next? I think,
Brian, I just was
Sharice.
gonna say, would a loss of credit expectancy be a tangible injury?
Well, you say expectancy. That sounds like you had applied for nothing.
Right.
Yeah, again, that would be the same thing. You fearing something that necessarily is just a straight fear. You hadn't applied and that's just your thought. They want, so again, to corroborate that, you have to apply and get denied for something and allege that you believe that, well, sometimes they'll give you a letter saying it's because of collections and stuff like that. But that will corroborate it. Just understand the point here is you're not going to get away with just your thoughts and feelings. Isn't that a song? A Drake got something else. What's it? Okay.
More like Future.
Okay.
Yeah, well, it ain't that hard to go apply for something, get denied if
Right.
you got collections.
This is in my feelings. This is another song.
Yeah, man. I mean, people, they make it too harder than what it is.
Thoughts and feelings.
Who cares? Go buy a Boeing 737. Who cares?
Right. The magistrate judge cited cases in which the plaintiffs presented evidence they suffered emotional distress as a direct result of inaccurate information in a clear report. Okay. But the plaintiffs in those cases tied their emotional distress directly to the defendant's actions. Did you see that? How do you tie it? You tie it by what? Words. So that's that Easter bunny grass and paint. Y'all like my illustration?
Mm-hmm.
So tied. For example, a defendant who reported unpaid loan against the plaintiff thus negatively impacting the plaintiff's credit score, preventing him from purchasing a truck, causing him emotional distress as he fought with the defendant to correct the report. Okay. The plaintiff suffered loss of sleep from, loss of sleep and extreme stress. Okay. You could stop there, right?
Mm-hmm.
From his actions, but they said from seeing the wrong amount due on his consumer report for several months. You see the little change? So it's the same thing except you put some grass on it. Okay. So there you have it. Oops. Okay. So, all right. These cases confirm that emotional distress alone can establish if it's caused by defendant's error. Indeed, it can likely be enough without any other impact. There's a mere false fact of false information. Okay. But plaintiff here has failed to present evidence of even the low bar. So again, the evidence meaning the tie, you distress, we allege, but you didn't have enough grass in it, so nobody wants to buy that basket. Plaintiff was asked at his deposition if the dispute notation caused him depression and emotional distress. He said it did. That alone might have been enough to establish standing. But plaintiff then explained that the true source of anxiety he believed, based on YouTube videos,
What?
notation would prevent him from getting
Oh my God.
mortgage. Okay. So he never applied, and that caused him to fight with his wife, who really wanted a house. Plaintiff presented no evidence the dispute impacted his credit score alone. In absence, his testimony demonstrates his emotional distress resulting from his perceived inability of what he watched online. Man, they scrutinizing him. His stress came from what he perceived from watching those videos. Good thing he mentioned him. The court finds it's too tenuous to confer standing. The injury must be certainly impending. Let's see. Okay. But it really does not matter, regardless of whether it's plaintiff's emotional distress confers standing. Defendant's false report to the credit agencies alone gives standing. Well, okay. So good. So they found him to have some standing just from that. So from that reporting. Now, what's weird about this is, there's a more recent case that talked about the standing needs to be not just on the report, but needs to have been communicated in that TransUnion case to a third party. So I'm surprised they were real generous on this one, not going into the TransUnion case, but whatever. I'm glad they made it. But you have to be careful. You got to allege that stuff real nice to put all that grass on it. The 11th Circuit explained that a statutory violation while traditional report the plaintiff's injury satisfies the concreteness of Article 3 standing.
And and probably, in 3 years, man, nobody ain't gonna be talking about this no more. No standing. That's still crazy.
So the steps after you see the claim, you gotta say
Why you say that, man?
Because it's a hunk of junk, man. So that's the thing, because this is the thing. Even though the Supreme Court is saying all this, so go back to the origin of what happened. I mean, it was a class of people, they got separated from who seen a report or who didn't see the report, So now they're saying, hey, you can't have a bare injury. You can't have a statutory injury, right? So let's use what the law of the land really is. So let's say that this is, the law of the land. I swear to God, as soon as you sue them, they're gonna be like, oh, we'll give you $1,000. Hold on, buddy. Hold on. We can't do that no more. You know what I mean? So now you like, oh yeah, now you got to talk about the TransUnion case. What are you giving me $1,000 for?
Right.
Oh, statutory? No, we can't do that. We can't do that. So now, because you bought, some Tylenol, you took the Tylenol, y'all head hurting, blood pressure up. Now we got to go hire an expert witness and say, you got to get this man 5 racks. So it's crazy, man. It's just crazy. It's when they want to do it. It's when they want to use it,
Right. Makes sense.
And then it talks about, to establish an FDCPA claim that to have a consumer debt collector, and then a violation, engaging in prohibited conduct. Pretty much they established it easily that there's a debt collector here, consumer debt, and then the violation is to false report. And basically they're saying here, as we talked about, that if it's not continue to mark a report disputed when it no longer is disputed is a violation, and then they have this case here that supports that. Continue to report to CRA that a disputed debt was owed, even if the plaintiff had informed the defendant they no longer disputed it. So that solves that. So this is a very, I'd say very sort of groundbreaking, to be able to appreciate the reverse. I call it a reverse E8. because we sort of, it's not the E8 you think about that's listed. It's now it's no longer disputed. Okay, but it's a couple more pages, but that's basically it.
Conclusion.
Yeah. So they granted summary judgment for the plaintiff, and they won. So we'll see. I guess we can pull this up at some point to see how much money they get. But
so man, no, it's still going up.
Most of us see. What?
So it's my opinion is the complaint. I mean, I ain't no English teacher, no, writing all that. The complaint, it is what it is, but it can be better. So what I think they kind of sort of missing, like to put the nail in a coffin, is a denial. You know what I mean? Of some sort.
Yeah, because the damage is not going to be very high. You see, it's all in his head, so it's going to be just based on his. The damage is not going to be that high. The attorney's fees, yeah, but yeah,
So
he should have worked that up a little bit better. That was a poor workup. The attorney will get paid.
Crazy, and I don't understand why people don't do that. Right? So as a plaintiff, you got the right. I mean, you got the ability to bring a case or not bring the case. Now, why not fluff it up?
Ooh.
You know what I'm saying? Like, come on, man. You got all these gurus out here talking about, hey, Navy Federal only pulls from experience. You know, go. You see what you doing. Hey, go over and apply.
Nope.
Right.
So okay, well, this is a great case. Now y'all know, if you didn't know. Is Tony on?
Yeah, Brian, I'm here.
Biggie Small said, if you don't know, now you what? Now you know.
Hey, he got that blue ink right there. They got that blue ink, that wet signature.
I see.
Don't, but the blue ink is like Trump said, listen, he used black ink. You got that blue thick marker, Michael Brown. Okay, well, all right, we got some submissions. Any questions about this case? This reverse E8.
That
Go ahead.
guy on TV?
Michael, what's that?
Michael Brown ain't the judge on TV.
So, federal judge. Okay, well, any questions about that? Was that useful? That's good information, right? To know. You can undispute even if you dispute it. Okay. We have a submission.
That was real good because I actually got several clients who got comments that says disputed. As soon as I got them and they weren't in dispute, they just recently hired me and I go look at the credit report and they're showing trade lines disputed that are not. So that's definitely very helpful.
Oh, okay. Good. Yeah. Okay. We have a question here.
Brian, I have a question. Let's say somebody has a settlement agreement. They can't send it to you as an attorney?
To them for what?
The question is, I sort of know, and I hate fixing people's questions because I don't want people to think the question is proper, but of course they can.
Okay.
Remember,
what is the appropriate way to ask that question so I don't forget next time?
No, it's you the master of the question, but I'm answering your question is yes, but that's not what you're really possibly asking. Yeah, they can.
Is it
but I don't think
proper
that's
or is it a violation? Is it
of what?
Well, there's not a
violation of what?
Okay, let's say the question would be, let's say someone has a confidentiality agreement and then they just want to send it to you. But I think that if you're a legal counsel, not to them, but if you're an attorney, that they wouldn't be breaking the confidentiality agreement, would they?
Yes.
Oh. Okay.
And why is that?
because you're not their legal counsel.
Yeah, not their attorney. Like it's like
Mhm.
sleeping,
Yeah.
it's like sleeping with somebody that's a husband. Is that your husband? You can
I can't go.
get canceled for this. Y'all cancel.
Okay.
Y'all cancel.
Is that bad if you do that?
Huh?
Sleep with somebody's wife?
Is it your one?
Oh Lord.
Community.
Community.
I don't have any names in this. So. Okay. I'm supposed to be reading this. Okay. Initiated arbitration with Santana for sending me a late text and self with $1,000. That's great. Y'all making money. First of all, let's get a round of applause. Where's my little? Is this stuff work? Let me see.
Let me get that hand clap.
Uh-oh. You gotta tell Tony who do that one. Who does that one? The hand clap one. A round of applause.
So what state is this in?
I believe it's in Florida.
Oh, you got. No. Did y'all hear their hand claps? No. Did y'all hear their hand claps?
No, sir.
Oh man, stuff. Okay, well anyway, Santander, man, late tech, y'all getting paid. What God, Before we went in for an arbitrator, they offered 0. Man.
This was an arbitration case, huh?
Yeah. And asked for me to dismiss the case. I told them no the first time. Then they offered 500. I said no again. Kind of offered for 25, and they kind of back with 1,000. Woo-hoo.
I like that. I like that negotiation.
Tony B.
Yes, sir.
How much is a stack? Is it 0, 500, 2,500, or 1,000?
Fonnie said.
Hold on.
Brian, you know me. I'm the guy with a very heavy accent, limited English.
Go ahead. We'll let you. You want to phone?
Slow
Okay.
learner. And
Okay.
the
So
list
you don't
is
know.
long.
So listen. You want to phone a friend, ask a credit mastery person, or you want to Google?
Yeah, credit master.
Which one? All right. Well, ask somebody. Who you want to ask? You gotta choose someone you want to ask for help.
From this group, now I got to ask. If it's not you, I got to ask Vance.
Oh man, why you choose the black guy, man?
No, man, come on, man, come on. You're the most knowledgeable guy in this group.
No, I'm just playing. Nah, man. You know that stack is at 1,000.
Yes, indeed.
So you want to go with Tony B?
You go with Fonnie Willis.
Is that your final answer? What's your answer, Tony B?
Well,
what's the stack?
All I know today, I settled the case for 1,500.
Okay, but
at the beginning, they're not paying me.
Come on now, stay on track. What's the stack?
I think 1,000.
Okay. Final answer?
Yep.
That's correct. That's a stack. Okay, all right. That's a stack. So next time, you know now what a stack is. Okay. I think it's best for me to take it. Yeah. For text. I really don't have any damages to prove. Well, don't ever say that. Why are you gonna say that? You can't think like this.
Whoa. So stay right there. Yeah, that bolded underline. So yeah, that kind of hit me in the side because I really don't have any damages to prove, right? So if someone is sending you a text message and the text message is unwanted, well, that's intrusion upon seclusion. So intrusion upon seclusion.
Yeah, you're annoyed. I thought you said it was annoyed up here. That's damages.
So I think they did put stuff to show that there was damages, but it wasn't the word I want to say concrete. But it was like one of the things how we were talking about here, like how you would want to have something like from Better Health, or you would want to have something Tylenol.
No.
But the intrusion on upon seclusion, I don't know if you. Well, I guess you can educate me on that if we can use that in state court.
Well, use it in any court. It doesn't matter. State.
Okay.
Court is court.
Okay.
You say a late text. That means it was during an hour where you shouldn't have been getting
Disturbed.
it. So you're secluded in your home or wherever you at, and that you were intruded upon by that text. And so that's intrusion upon seclusion. Now, yeah. Okay.
So that enough would have been good to get
Yeah, all
to
of that
really
annoyance,
mhm.
headache, you had to jump
Inability.
up,
It
hit your
was like
foot, trying to
inability
get
to sleep. Had a hard time
all
in
that.
work the next day. It was, a
And then,
lot.
right. And remember, if it's in federal court, you got to put the Easter egg grass and stuff with it. And that's why that case I sent you. Yeah. Well, obviously, that case I sent had bad language. Well, you got to tie it into, you remember that opinion, you have to tie it to the behavior and not just what you saw on YouTube.
Okay.
You got to tie it to the defendant's conduct, not just from
So
perception.
Nancy, I don't know.
Yeah.
What your phone sound like, but when my phone, if it vibrates or ding, I mean that's
Mhm.
peace and quiet, and the courts have ruled that that's a valuable violation, actual damage.
But yep.
How did you find that case? Because I've been looking for something in particular for that, like, because you said the court ruled that, because that would be really good just to know.
Oh well, I gotta search up my computer, but yeah, it's dealing with intrusion, so it's basically peace and quiet.
Okay.
Wesley says, and going into a negotiation is critical. All right, well, let me I'll just paste this. One second. And I was taking the chance of my T-Mobile records confirmed that they did send it on the time, but something with my phone did not allow it. So I took it nonetheless. The agreement they sent me seems restricted. Okay. Here's a comment. Let's see. Oh, I'm sorry, Wes. I thought I had the comment. Let me answer this comment.
Man, Wesley, you gotta get like Charleston White and say, "Damn that confidentiality, man." And
No,
just put it on out there.
this not Wesley's. Wesley just had a question in the
Oh,
comments
okay,
section.
all right, never
I just
mind.
I just want to review it. Wesley, you there?
Yes, I'm here.
Okay, we go answer your question.
No, I was just, it really wasn't, well, I mean, you can answer it. I mean, I was just like reading the whole thing, and I mean, I deal with this all the time, so it was kind of like a comment or suggestion, because the person was going back and forth and they didn't kind of know what to do. So about negotiation is about needs, and that's all. That's all I was just trying to point out.
Perfect, good point. Due to confidentiality, I can't share the specifics with the clients, but I have attached to the email because I can share it with legal counsel. Okay. Well, all right. I emailed the company about drafting a complaint with a stupid demand. And we had talked about, he said that he would let the client know. Anyway, I will say this, that's a great result. That $1,000 for that text. I would have probably, tried to add the cost. Well, if you didn't have to pay for the arbitration, that's great. If you had to pay anything above
Nah,
that,
they pay for it.
oh, excellent. That's great. I thought arbitration was a creditor. Okay, this is the same scenario. The paragraphs below stop me from making any claims in the future. Okay, we'll take a look. And this came up actually. Warren has a sort of case like this where we settled the case against Portfolio. And guess what Portfolio did like a year later, recently called his wife, and now we're suing him again. They're trying to say the settlement agreement included future violations. I'm like, y'all are some
Right. So
idiots, dude.
that's one of the things. It's kind of
Yeah,
like they're just
y'all
trying to cover
crazy.
themselves for
Yeah,
everything, like
you gotta,
forever in life.
I understand. You got to be careful with that. So, in exchange for the good of bad consideration of suspicious risk, hereby claimant include each of her affiliates. Yeah, you can delete affiliates because there's no affiliates. This is bad. Like, you delete that. I'll do this. Let's do it. Yeah, you delete that. There are no affiliates because humans don't have affiliates. So if you leave that in there, it could be your whole family. You're affiliated with the whole family.
Oh, wow.
But so claimant. So basically, you delete all this. This is BS. Okay. Hereby releases, acquits, and forever discharges defendant and each of its respective affiliates. You can think about that. From any and all damages claims, a liability all be out of or related to the same or related claims, or they could have been raised, assault, in or arise out of arbitration or subsequent litigation. Related. Now, here's the part that is from the beginning of time to the day of the agreement. Okay, so this is what stops it from addressing stuff that happens in the future. Okay, so but anything that happened from the whether you believe in Genesis and the Bible or the Big Bang. Okay. Oh, they were Chandler there. He wrote the complaint, then. Chandler talk about.
Yeah, he's say hi to Brian. Say hi to Brian.
He working, man.
No, we talk about it. Yeah, so he's the one that types the complaints that Vance does. He does a pretty good job, but I don't be typing. All right. So anyway, whether you believe in the Genesis 1, let me get my Bible.
Oh man, this turned into a different kind of meeting now.
Right. Whether it's Genesis 1, let's read it, see what it says. In the beginning, God created the heaven and the earth. That's Genesis 1, chapter 1. So whether you believe in that, that's when it starts, or you believe in the Big Bang. Okay. That's when the agreement starts. So they violated you from Genesis chapter 1 or the Big Bang to the date of the agreement.
So basically, anything that they did in Genesis up to today,
Yeah,
cannot be.
It's forgiven, like the Jesus,
It's
like on the
forgiven.
cross.
Oh, okay, that's good. That's a good analogy.
All sins forgiven until that date.
Okay,
now,
for a little.
Anything happen after that is fair game. So anyway, it looks real tricky, but once you get down to this part, this is what takes you from Genesis or Big Bang to the day of the agreement. So it seems crazy up here.
Yeah,
but you don't have to worry about it. It's just anything that happens later. But like in the case of this portfolio, they're saying, oh, it includes all this, what could have been asserted. Well, but it's to the date of this agreement. You can't assert something, nor is anything covered after the date. Does that make sense? So, so anyway, anyway, that's whatever. So anyway, that's fine. As long as you don't have any other charges, you can't be like the P. Diddy situation and come back later and say, you got touched or something like that. Okay.
Okay. So even where it says claimant will not seek anything in the
okay, well, let's continue. Except for the consideration described in this agreement, claimant will not and shall not be entitled to seek anything further from the defendant. That's a weird thing to say.
It's like they contradicted themselves.
Yeah, you should have a consideration section, and in that section, you should say, used to say the only consideration would be this. So you don't need to sort of, this is weird. I would take that out.
Okay.
And you should have a section of consideration. And then to say you will not seek, because here you're saying, except for that, you will not seek and be entitled to see anything further. That's separate from this sentence from Genesis to today. And they could use that against you later, saying, "No, what you said, you except for that, you'll never seek anything else." That's different. This has to go. That has to go. They're crazy. You see what I'm saying? But yeah, you gotta be careful with that. I'm telling you, they're getting stuff right there. But yeah, that has to go. It has to go. Okay. These documents, they get real fast. It's just so that they can
Yeah, because they just
in the future.
It's like people get excited for the money,
Nah.
and then throw away all their other
Yeah.
rights away.
Mm-hmm. That's right. Okay. Okay. So yeah, that has to go. Dismissal of claims. Claimant agrees that she has released. Well, yeah. Well, it can be has. What's it in a moment? You know what I'm saying? It's not has. Yeah.
Yes, that makes more sense. Because nothing has, yeah.
You know, it's not has. So whatever. You know, something along that line. Because what you don't want to do is release people by your signature before you've gotten paid. So the thing is to get paid and then submit paperwork to the arbitrator to release it. Whatever language, whatever you file. All right. This is it here. Down here, it's the same thing. So you was basically say that you would tie this together that she will do what you have here within 5 days. See, the same thing. So I don't know why they would say has and then say shall. So
Brian,
go ahead.
Quick question. So if you are negotiating outside of court, and you guys come upon a settlement agreement amount, you're saying don't sign off on releasing the claim until you receive payment?
You see how they said you go do it within 5 days of receiving an agreement? Who cares about a freaking signed agreement? Where's the money?
Right.
You see what I'm saying? They're saying within 5 days of, nah, man, what's my money?
Also, the money comes first, then you release.
It ain't coming first according to this agreement. You want it to come first before you tell the arbitrator we good.
Okay.
What you had here says within 5 days of getting a signed agreement, you telling them we good. We're not good until I get this Monday. Tony B, you still on?
Yes, Brian, I'm here.
Yeah, so no money, no blank.
No honey.
You gotta let Tony B. No money, no what, Tony B?
Yeah, no money, no honey.
Yeah,
But
see?
I have a question, Brian.
Go ahead.
But I have a question. But
Yeah.
wouldn't can let's say if defendant fails to send the compensation to Nancy, I believe then she would have valid case against the defendant.
It's not me.
because there will be.
It's my friend.
I'm sorry. I would just make.
Is it like a is it like a
Yeah.
Nathan Wade type situation?
Okay, but all right. But I thought even if they would delay or maybe something, then the
Yeah, but yes, you have an executed agreement, you have a claim, but still, you don't want to be fighting over that. You want that money. You want that case to stay, that arbitration to stay alive until they fulfill it.
Okay.
You don't want it to die and then be waiting. You sent the money yet? They
Because
can take
then
their time.
they have the upper hand and they'll take their
Yeah,
sweet time because
time.
you. Oh, okay.
Who
So they would have to probably what would it because it's can you that's one of the
manage-
questions I want to ask. Can they do wire transfers instead of
yeah,
paper checks?
why that thing?
Okay.
Why that thing? You have to indicate it. If it's not in writing, it's not agreed to. So yeah, wire. The instructions should be in the payment paragraph. You say a check to the order of, or paid via ACH or wire transfer.
Mm-hmm.
According to the following instructions, you can put the wire instructions right in that paragraph, or attach it as a separate piece of paper.
Okay.
Okay. To the extent the claimant fails to do so, claimant hereby provides her explicit consent for 4 of 7. Oh, hell no.
Wait.
Oh, let me
what?
see. To claimant provides consent for, I don't know, this is probably just redacted, to file a joint stipulation on her behalf. I mean, once, no. Well,
Oh,
you got to say it has to be signed.
within that time frame, or they can dismiss it themselves.
Um, I would just take this out, but I mean, here's the thing: a joint stipulation would be signed by both parties.
Right.
If the above conditions are satisfied by whoever the respondent is, if you want to keep that, but I think that's a little weird because the obligation is agrees notified that arbitration shall be dismissed with yeah, this is really, I can't spend too much time on this. Is really poorly written. That's why you have to have an attorney review this stuff because
It's a lot of double talk in this.
yeah, this
Like
is
they
horrible.
saying one thing,
Yeah,
and then later on they speaking something different. A lot of this needs to be struck.
yeah, this is
Make
really
sure you get your money within 7 days too, because they be trying to play games talking about 30 and 60
Okay.
days. No, 7 days.
you got to put the days. This
You
is
Okay.
gotta do
saying
all
shall be
that.
dismissed with prejudice. And see, even this is not, it's elusive because it should say that both parties, like once you get the check, the attached drafted stipulation shall be signed by both parties and filed. Should have every direction like Google Maps. This
Mm-hmm.
is just real loose. No future claims. Claimant and her affiliates. There are no affiliates. Okay. That'll make any sense.
Right.
That not assert or file any future claim.
Can I make a quick comment, Brian?
Yeah.
I believe in arbitration, it's not defendant, it's a respondent. I'm not sure if it really makes any big difference, but in arbitration, we don't call plaintiff and defendant, we call respondent and
You're
claimant.
right. Yeah,
But
I
they
don't know.
keep calling defendant.
I think, yeah. I think she put that there to redact the name of it. But yeah, that's right. Respondent shall not assert or file any future claim, okay, that could have been, well, this is already provided for up there, but anyway. That it could have been made in arbitration.
All that is just stuff
Against
that they're
affiliates.
saying.
They didn't hear right receipts. Vehicle. I mean, it should be a vehicle, but maybe it is out there. The email. Okay, well, let's be careful about this double talking about future claims because they don't talk about Genesis and stuff over here. So if it's not about Genesis today, then you got to be careful when you start talking about future claims because
Right.
there's no window of time. So you may have to pull this just chapter 1 language there. You see what I'm saying? Because otherwise it changes things drastically. The affiliates include debt collectors. So again, and I'm glad you mentioned affiliates again because what if this company owns 100 debt collectors you have separate claims under? If you're going to talk about affiliates, tell me who your affiliates are. Because how can you evaluate whether you are releasing some affiliates? Because you're not releasing affiliates for what happened here. You're releasing affiliates for anything that happened from the Big Bang of Genesis 1 until today. So you don't know if they stole your income tax check or something like that. Then you're releasing them from that. That's funny. Why aren't you laughing, Sharice? You know that's funny. Yeah, I know I'm funny. I saw Cat Williams last weekend.
Was he funny in person?
Oh yeah, it was funny. Monique, Thomas Davis. Okay, so anyway, well, now Nancy got her money's worth because I was charging my $500.
You surely would. Gotta be smart about that.
$500.
I gotta start doing that.
That crap. But yeah, that's that. Open Q&A. Anybody got any questions? We overtime. Yeah. Overtime.
Yeah, I got a question, Brian.
Go right ahead.
So with my the one case that I got, it was something that I just found out that I didn't know that I can have Article 3 standing by mailing something to them. And back in April last year, when they sent me that letter, I did send the guy John Erickson a letter saying, "Hey, you guys sent me something. You should know I'm retained by counsel. You should just come to a settlement with my attorney so I won't have to pursue this violation that you commit right here." So I don't want to get myself in a trick bag where because I didn't know that mailing something could be considered standing, and I wrote that motion to remand. So I'm kind of in a situation where they might look at it like, well, why did you write that remand if you mailed this guy something? Because I mailed him something twice, something in April and then something later on in October.
Let them prove it. That's their problem. The standing, the burden of show standing is on the removing party. Okay.
Oh, okay.
So they need to highlight the fact that you have concrete injury from mailing.
Okay.
And if they don't, then vote.
All right.
Okay. All right. Anybody have any other questions? We'll wrap it up.
I got another one. Would you be interested in taking on a situation with Bank of America? The short version is this: person gave Bank of America $1,000 for a secured credit card. They were supposed to give them the money back, over a year. They didn't do it. What they ended up doing is they put the money in a CD. And when the person called to say, hey, why haven't my funds been released? They said, oh, we put it in a CD. So, and they have the agreement. Okay. I will
study that.
I'll gather for you and send it over.
Yeah.
But yeah, Bank of America,
Well,
you know,
before you
they
send it, I want you to. I don't do a free read of it, but I'm asking you take a look at it and study it to see.
Oh yeah. I will.
Or you
I will.
Cordova Capital. But no, I'm not going. Yeah, I mean I can, but I would have to do a consult. If you want
Yeah,
me to
that's
read it.
fine. That's fine.
If the
But
person wants that,
I'll read it over.
Yeah,
I'll
to
read
see
it
if
over before, just so we on the same page. And
yeah,
if there is something that's tricky with it, then I point it out to him, say, hey.
yeah.
But yeah,
I could consider it and study it. But yeah, if you study it and it clearly says after this period of time we'll take your money and make it a CD, or if it says it'll be returned, then you can tell me, hey, it says what it says.
got it.
But I don't mind
Okay.
reading. I just try to save people.
Yep.
some
I
time.
totally understand. Totally understand.
Okay. Let's see. We got a little chat.
Fine, and in that case, what loss, what protection loss would they violate? It's not FCRA, it's not FDCPA, it's like,
Conversion.
okay,
It could be deceptive practices too,
deceptive.
but it could be a conversion case. It's stealing their money, $200. Supposed to give it back.
1,000, 1,000.
It was $1,000. Okay.
Yeah, it was 1,000.
Yeah. So yeah, I'm interested. Let us know.
I will.
What that
I'll
agreement
gather the
says.
docs,
But yeah,
read it over, and then.
but it's interesting.
Yeah.
Probably has arbitration clause in it too. But that's cool.
Ooh, yeah, it might. I don't know. I don't
You
know
never
if
know.
Bank of America has it or not.
Yep.
But
Yep, you can find out.
okay.
All right.
I think Bank of America dropped their arbitration clause a couple of years ago.
Okay.
Brian, for us, I forget just really quickly when you talked about us opting out with the CRAs, we just have to write a letter, or we can give them a call.
I think Tony had indicated.
We can call, Tony said, right?
Yeah, but
Yeah, that's what I did. I called them up and I record the conversation. Yeah, and then so
yeah.
Perfect.
And I mean, on the arbitration agreement, it says if you want to cancel it, you could call us this phone number and ask us to cancel, and that's what we did. Call the same number that they disclosed, and then I called them up and canceled it, so it was successfully canceled and it's on recording.
So you canceled all your services and affiliations with the company?
What you mean? Oh, I used to have Experian free version.
Yeah.
Yeah, and I canceled that.
Okay, that's what I'm talking about. Okay, thanks, Tony.
Sure.
Yeah. So any of those
Quick question, Brian. On the motion to vacate, right? If they grant the order the motion to vacate, does that mean the case is thrown out? I don't have to go in.
It just goes back to before judgment.
Okay.
So it's still active. So if the judgment is vacated for non-service reasons, then they have to serve. If it's vacated on other reasons, then you have to defend right away. So it depends on what kind of vacatur, but it just takes you back in time to before the judgment. Okay. So is this a situation where the person was not served or they were served? And
yeah, it was. Remember, in my case where they didn't serve me, it was improper service, and you said that then the judgment is void. So go ahead and file the motion to vacate.
Right, that would take you back, and they would have to serve. Okay, but yeah, it doesn't kill the case. The case is still alive.
So if they can't get me served, then it's just still hanging.
It'll
right?
sit in suspense. It'll sit in outer space like your background is. Yeah.
Right.
Y'all know I'm funny. I should open for Kate, really.
Yeah, you funny, Brian.
You a crack up.
So okay, well we're gonna go. We're over time. Y'all have a good evening.
You too.
All right.
Thanks so much. Good.
You're welcome.